Hey everyone, and welcome back to the channel. Today we're looking at a video originally featured by Van Balayan, a creator known for covering unusual courtroom moments and sovereign citizen encounters. If you enjoy this type of content, be sure to check out the original video and support the creator. This particular case immediately stood out. It involves a sovereign citizen appearing in court, refusing to cooperate, challenging the judge's authority, and eventually making one of the worst decisions imaginable. By the end of the hearing, the situation spirals completely out of control. Let's
here. Also have Mr. L back here as well.
All right. This is the Eddie Banks L matter, and 3A0225-485. Mr. Banks L, you want to come forward?
You really wish to engage me?
Yes, I do. You come grab a seat, or you want to welcome to stand up? Come to sit closer to the mic.
No. See, this is a arena of honorable men.
It didn't take long. Right from the start, this defendant manages to make the situation worse for himself. Instead of showing respect for the courtroom or trying to present a reasonable argument, he immediately creates unnecessary conflict. As you'll see throughout this video, confidence without legal understanding.
This was on, there was previously a competency evaluation ordered. There was some non-compliance with that, but ultimately, most recently on December 4th, a new out-of-custody competency evaluation was ordered, and that's the last status that I have. All right, anything to add, Mr. Smith?
I've been assigned as Mr. Elbank's attorney, but it still doesn't talk.
All right. Well, Mr. Banksell, what we're looking at is the evaluation hasn't been done yet. Last time we talked about how it's court ordered, and the preference was for you to do it out of custody instead of in custody. We're still in that same.
What don't you understand about free will and free sanctity of mind?
Well, I understand that. We've talked about this before, that you're ordered to do the evaluation. You have a couple of options. You can do it out of custody, or you can do it in custody. You agreed last time you did it out of custody. There are changes to that agreement?
Yeah, there have been changes.
Okay.
After you finish doing what you're doing, so
I'm done.
you're done?
Yes.
So is it my turn?
Welcome to go.
Okay, welcome to go. All right, I'm giving notice of case number 24-2010-8931. Since you don't want to listen to me, Honorable, you don't want to listen to documents, I have here a statement that's been published. Oh, can I give copies? My bad. I don't want to scare y'all because I'm an honorable man. I'm not trying to hurt anybody, but I got to get my point across.
It's called an offer of proof.
Yes, it's an offer of proof.
Just tell us what you want to give to everybody.
This is a declaration of independence, letting my political will be known. You don't have any interest, and I'm not a beneficiary to these proceedings. You just want to tap into my blood.
You'll notice with many sovereign citizen cases is the consistent resistance to competency evaluations. Whether it's because they distrust the legal system or genuinely believe their arguments will hold up in court, they often fight the evaluation itself instead of addressing the charges they're actually facing. Unfortunately, refusing to cooperate usually creates even bigger legal problems than...
No. This has been public. Yeah, this is something new. So can I give you all a copy?
I'll defer to you when you're okay with
There you go. Thanks. Summon. Oh, it's public. It's not a problem for the city and for yourself. All right. So the next step, if you want to continue, what I'll do is every state official who wishes to continue, when I bring this federal matter, there will be no excuses, no reliance on, I didn't know, I didn't understand. You tried to rape this man's individual free will. I'm not having it. So that's all I have to say. You can continue on as you please, but I'm telling you, you're not free from the consequences.
So, Mr. Banksell.
The discussion has completely moved away from the legal issues and become personal. Instead of presenting facts or making legitimate legal arguments, the defendant resorts to insults and confrontational behavior. Courtrooms aren't won through emotion or outrage. They're won with evidence, credibility, and respect for the.
I understand. If you want to bring proceedings, you have a right to do that, right? But where it leaves us still is you're ordered to do this competency evaluation.
No one has the authority to order me to do anything.
Well,
For what reason? What proof?
So the court's ordered it. It's there in a court order. And again, the situation that you're in is you have to either engage in that out of custody, which you agreed to last time, or what we can do is find that you're not compliant with the conditions of release, amend the bail order, and then you'll have to engage in that evaluation in custody. It is still one moment, it is still very much my preference that you engage that out of custody. I don't think that there's any reason that you need to be in custody to do the evaluation, but one of the reasons that you would have to do it in custody is if you refuse to do it out of custody.
Tell me, why do I have to see your people for an evaluation?
Well, that's something, a conversation you can have with Mr. Smith, and we talked a little bit about.
No, it has to be.
One moment, Mr. Banks, you'll have a chance. So, you have the right to present evidence about the competency, the status of competency if there's a disagreement about the report. You have to engage in the evaluation that's been ordered.
Okay, so who's here to compel you to perform according to my trust res?
Well, if you're asking about who else could assist you in getting an alternative evaluation,
No. I'll do this. I'll do this.
About that last time.
Yeah. I forgot. I've filed this too. Let me make this a part
I
of
think
it.
that's already been, I can kind of see it from here. I think that's already been filed in court. So, let me.
No, not this. You know what it is?
Well, I see the seal, so I guess it looks a little bit.
Yeah.
Defendant continues relying on theories and documents that simply have no legal authority. No matter how many unofficial seals, homemade paperwork, or self-created legal interpretations someone presents, courts recognize only valid law and established legal procedures. That's why these arguments consistently fail. The legal system doesn't operate on personal beliefs. It operates on statutes, precedent, and constitutional.
This is a choice of law. Living trust law. Nah, I just created that, buddy.
Well, it's great for me.
Okay. Only the flag and the seal. So we're going to see. Because we're going to enforce contracts. You want to enforce yours on me? We're going to see. We're going to see if the republic and the law is real.
All right. So, Mr. Banksell, the decision that we're talking about today, you're ordered to engage in the out of custody evaluation. Less than a second. What we're looking at is, I haven't had any information, and you remember what this was like. I assume you remember what this was like several months ago, that the evaluation wasn't engaged in, and the conditions of bail were met. Call that?
Keep creating evidence against yourself, man. It's fine.
All right, well, certainly all of that's in the court record. Whether you want to agree with recalling those events or not. But we're at the position where if we're going to do that again, then the conditions of release simply need to be amended and you need to be back in custody that you're engaging that evaluation.
Okay.
Last time we were here, you agreed under what you described as duress
Okay.
that you would engage in that evaluation out of custody. And I want to make sure you're still on that same page, that you're
Okay.
agreeing, although it's something you don't want to do, and you're.
And it's going to be public. The evaluation has to be public. Because I don't trust you private individuals, because look at what you're doing.
So, Mr. Smith, part of that order is he can engage in the evaluation and be there, and then really that's between however that evaluation goes between, between you, between Mr. Smith, and it's between the evaluator. So, that's something, I can't make a decision about whether it's public or not. This is your private information. So you're gonna have to leave it up to the evaluator. If you want to somehow publicize this or have somebody looking at it, that's your decision in combination with the evaluator, okay?
It's my turn now?
Yep.
Okay, so again, I need to assess why it has to be your people, because I've experienced this before. I've already had one independent, and you are rejecting that. So tell me why this specifically has to be your people. Because hold on. Because your person can tell me to my face and write down this and that and the third, and then report and say, oh, he's suffering from psychotic disorder, NOS, not otherwise specified, yada, yada, yada. So that's the problem. So if we can get an independent party, then yeah, I will consider it. But no,
Things take another unexpected turn. After resisting the competency evaluation, the defendant suddenly agrees, but only if it's performed by a doctor of his own choosing. That's obviously not how court-ordered evaluations work. The court determines the process, not...
I am Jamil of the Family Law Court.
Well, you got to make your special appearance to the Wayne County Jail. I told you that.
Surprisingly, that proposal goes nowhere. Once a competency evaluation has been ordered by the court, the defendant doesn't get to rewrite the rules simply because he disagrees with them. Ignoring lawful court orders almost always creates more consequences than cooperation.
We were going to get your own private evaluation.
and I provided it for the
You were
court.
going to use that instead, and the court said that was fine, but you haven't done that yet.
What do you mean? I provided the proof.
Proof of what?
Mental evaluation.
When?
The last time we were in court. You don't have it
I
now?
wanted a new one.
Who wanted a new one?
We need one that's contemporary. A couple of things. One is, you talked before about some of the other experiences you had. I want to be clear again, that this is not any sort of restoration evaluation. It's not sending any sort of order of restoration. It's not any order that requires medication. Nothing about a blood draw, anything like that.
Can you give me 48 hours to inspect all paperwork, all contracts that is supporting the transaction?
One second. Let me finish. We'll get back to that. And all this is speaking of something. There's no treatment, no medication, nothing. Okay, so I want to be clear about this evaluation. The authority is the statute that provides that Washington State Health Services can provide these evaluations by court order. You are welcome to submit one. Dr. Smith has talked to you about that. The court filed in public. I think in the past, gone to the court, file certain copies of the file. They're all there. Where I'm left is something that you just said, is you will not engage in this evaluation with your court.
Because I don't have a reason why. Why?
Because you're ordered to do it out of custody.
Who has the order? Tell me what reason, what authority does that?
Mr. Banksdale, this is...
The judge now lays out two straightforward options. Complete the evaluation while out of custody under the court's conditions, or complete it while in custody. The court already has jurisdiction over the case, and the defendant's choices at this point will determine how the situation unfolds. Unfortunately, instead of making the practical decision, he chooses the path that only makes
out of custody order that orders the evaluation. I can give you that. And it goes over the The problem is, if we leave here, or not leave here, if we can't get to the point where you agree that you'll engage, even if it's under duress and something that you don't want to do in this out of custody evaluation, the only option that I have is to amend the conditions of release, set bail, and then you'll engage in it in custody.
I've already given my declaration of political separation. You're free to do whatever. Notice has been put in the living trust for protection with the Sheriff's Department, with the U.S. Marshals, and the Police Department. So that makes their departments liable. So whatever orders, paperwork you want to push through, if they want to put themselves on the line to defend you, then so be it. But I have made my will as a man. I'm a reasonable man, non-violent. I don't talk. But what you're trying to do, what you're doing to compel me to do something that I do not wish to do as an ordinary man, That's unacceptable, man. That enrages me. I'm willing to call mutual combat since we can't settle it on paper. Let's settle it like men.
Then comes the moment that changes everything. The defendant actually challenges the judge to a fight inside the courtroom. Besides being incredibly inappropriate, it's also one of the fastest ways to destroy whatever credibility remained. Disagreeing with a judge is one thing. Threatening or challenging one is an entirely different matter and can lead to serious legal.
I'm going to engage in the out-of-custody evaluation as ordered.
My political will has been made known publicly.
What's the current conditions of release?
Go ahead, man. Do your will. Oh, I'll stay and get it on because this is live on Facebook anyway. We're going to see.
So I'm going to call, we have an officer here, I'm amending the conditions for bail.
Man. I'm gone. I'm gone.
Bail's going to be forfeited.
I'm gone.
I'm setting bail right now, you have $200,000.
$200,000.
In that astonishing decision, the defendant heads for the exit. At this point, it's difficult to imagine the situation ending well. Challenging the judge, ignoring courtroom procedure, and attempting to leave only compounds the problems already facing him. Every step seems to create another legal issue instead of solving the
Well, you've had the opportunity to engage in this out-of-custody evaluation multiple times. You're not following the conditions.
So you're going to strong. Okay.
I'm setting bail, the amount, your bail is...
Nah. See,
Mr. Bexell, the opportunity is over, unfortunately. Your bail, your bond is being forfeited.
all right.
It's being set to about $200,000.
Yeah. Well, that's a crime. That's for the public. Hey.
Welcome to stay here.
No, sir. You've been served a summons. If you go and do that, come on. I'm ready to go, man. I'm ready to go. I ain't playing that shit. $200,000. $200,000 to have me. That's one of them right there. Look at her. She was on the case too. Fucking fraud. $200,000.
where this encounter comes to an end. Walking out after your bond has been revoked and after being ordered to remain in the courtroom can result in additional criminal charges, depending on the circumstances and the applicable law. This entire case is a reminder that courtroom behavior matters. Respecting lawful orders, presenting legitimate legal arguments, and cooperating with the judicial process will always lead to better outcomes than relying on conspiracy theories or confrontational behavior. If you enjoyed this breakdown, be sure to like the video, subscribe to the channel, and turn on notifications so you don't miss future courtroom and police encounter analyses. Thanks for watching, and we'll see you in the next one.